Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that I'm going to bring you right now is a ray of sunshine on a cloudy election season. We've got a judge in Illinois that just backhanded the crap out of the attorney general in Chicago. You know, that guy who pushes gun control all the time. Yeah, the judge says, explain yourself. Who wrote it? I want to know all the details. Tell me more about how I'm a danger to society. You guys are going to love every second of this because gun control is about to get called on the carpet. Now, of course, everything will be linked in the description box below. I cannot wait to hear what you guys think about this one. Hopefully it brightens up your day and you send this to everyone you know that needs a smile. And of course, make sure you hit that like button, subscribe to the channel, turn the notification bell on if you want freedom from west to east, north to south. And thank you for that consideration. All right, guys, let's take a trip to Illinois because, you know, the gun controllers know how to gun control in Illinois, and the judge is not having any of this crap. Listen to this. The attorney general there got slammed. Illinois apologizes for implying judge's transit carry ruling brings safety implications. Now, this came out about 3 hours ago. You can see right there. 3 hours ago. Trace auras if you are in these swing states on the border. All right, listen to this, guys. You're going to love every second of it. I almost guarantee it. It's like Men's Warehouse up in here. All right, let's get it. The Illinois Attorney General's office has apologized to a federal judge demanding answers after implying his ruling against the state's mass transit concealed carry ban has safety implications. So they did that thing that gun controllers always do. When the judge doesn't do what they want them to do and enforce gun control, which is unconstitutional, they always say the judge has made a dangerous ruling. It's incredibly outside the scope of normalcy. They always do that. Well, this judge ain't having it. And he's like, oh yeah? Oh yeah? Watch this. Northern District of Illinois federal judge Lane Johnson ruled the Second Amendment is violated by the state's prohibition of people carrying concealed firearms on mass transit. The entire thing here is about the gun controllers not being able to have their gun controlled on mass transit. Let's continue. Quote, plaintiff's proposed conduct carrying concealed handguns on public transit for self-defense falls within the presumptive ambit of the Second Amendment, meaning you can do it. Shifting the burden to defendants to show that the Firearm Concealed Carry Act's ban falls within the historical tradition of firearm regulation in this country, Johnson wrote. Now, the thing that they're trying to get pissed off about here is that, hey, prove it through Bruin. That's what that means, okay? The judge says, hey, if there's historical context for what you're doing, bring it forward. There isn't? Awkward. So what they did in the Attorney General's office to basically defend their gun control, they appealed to an emotional argument, saying the judge is a big poo-poo head. All right, check this out, and the judge was not having it, guys. This is going to be great. The state appealed, and in a motion said, quote, the potential safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line, so on the train Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. So again, implying that the court was guilty for this, or guilty of inciting this. Keep in mind, the guy who killed these people, all of them were sleeping on the train. He killed them in cold blood. He was a convict. He was a arrested felon who was out on no bail. So yeah, you enjoy that. Somehow still a firearm. Let's continue though. This is where the judge gets the backhand out. Johnson demanded whoever wrote that to answer questions during a hearing scheduled Wednesday. Oh, you know I'm covering that one. Quote, for example, and by no way of limitation, counsel should be prepared to articulate the reasonable inquiry that was made to determine if the suspect in the CTA's Blue Line shooting possessed a concealed carry permit, and if so, whether he brought the gun into CTA property to protect himself, Johnston wrote. Moreover, counsel should explain the reasonable inquiry as to how the suspect was protecting himself from the sleeping homeless people when he allegedly shot them. Get some more! This judge is basically saying, oh, really, this mass murderer, this guy, the whole person who walked in and killed people in cold blood, did he have a concealed carry permit? No, he didn't. Was he a felon? No, that's weird. Yeah, he was. Did he just aggress these people? Or was it self-defense when they were sleeping? He's openly mocking them. He's going to tear them a new one on Wednesday, and I'm so here for it, because this is what they always do. But let's continue. Let's listen to the groveling, because the Attorney General for Illinois, all right, quote, the sentence was not intended to suggest that the perpetrator of the Blue Line shooting held a concealed carry permit, because they didn't, acted in self-defense, because they didn't, or engaged in conduct permitted under the court's order, the attorneys wrote Monday. The sentence was also not intended to state, suggest, or imply the court's order was responsible for or specifically related to the shooting referenced in the stay motion, and counsel apologizes if any such inference was mistakenly created. Inference was mistakenly created. Really? Well, let's go on up and see what they said again. Let's see if we can just ascertain what's going on here. The state appealed and in motion said the potential safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line. Seems to be the counsel inferring the court had something to do with it, in which 4 people were murdered with firearms 3 days after the court's order was entered. That's weird, guys, because it kind of, what they say they didn't do. Oh, sorry, I passed that. I was so excited. I believe the last sentence here was, let's see. The sentence was also not intended to state, suggest, or imply the court's order was responsible, sounded kind of like that, for or specifically related to the shooting referenced in the stay motion, and counsel apologized if any such inference was mistakenly created. Or you are a gun-controlling acolyte in the state AG's office, and you're a gun controller, and you wanted to really stick your finger in the eye of the judge as he's responsible for the gun violence that was created by a murderer. Yeah, get wrecked. I can't wait until Wednesday. It really seems, at least this judge, is kind of fed up with the BS that the gun controllers are always putting forward with this emotional terrorism that they're always laying on the feet of the judges when all they did was uphold the court and the Second Amendment. Yeah, I can't wait for the rest of this one. It's coming out Wednesday, so make sure you guys are tuned into that one. Everything will be linked, and I will see you on the next one. I'm Braden. See you later.